Let's break down a blockbuster Supreme Court decision from early June 2025. The US Supreme Court just cleared the way for a $1.29 billion lawsuit against Antrix Corporation. Antrix is the commercial arm of ISRO, India's NASA. The case: Devas Multimedia wants to enforce a massive arbitration award against Antrix. The Supreme Court didn't decide if Antrix owes the money, just that the lawsuit can proceed in the US. This is a huge win for Devas, keeping their billion-dollar claim alive. On one side, Devas, holding the arbitration award. On the other, Antrix, owned by the Indian government. The real question before the court: can a US court even hear a case against a foreign government's company? Normally, foreign state-owned companies have sovereign immunity, a legal shield. But there are exceptions, and that's what the Supreme Court just clarified. The justices said, yes, US courts can hear this case under certain conditions. The billion-dollar legal battle is officially back on. The stakes? Enormous. And the story is just getting started. Meet the players. Antrix Corporation, ISRO's business arm, selling India's space tech worldwide. They're not just a company, they're an extension of the Indian government. Then there's Devas Multimedia, a startup with a bold plan to deliver satellite-based internet and video across India. In 2005, Devas and Antrix struck a deal. Antrix would build and launch satellites. Devas would lease the S-band spectrum. The goal: revolutionize digital communications in India. The contract was worth hundreds of millions, promising a new era of connectivity. For Antrix, it was a chance to flex ISRO's commercial muscle. For Devas, it was the key to a massive market. It looked like a win-win partnership. But as we know, things didn't go as planned. The deal was ambitious, risky, and ultimately explosive. What started as a technological dream soon turned into a legal nightmare. The seeds of the billion-dollar dispute were sown right here, and the fallout would be global. The 2005 contract put Antrix on the hook to provide Devas with S-band spectrum, prime real estate for mobile communications. Devas geared up to launch hybrid satellite services across India. But in 2011, the Indian government abruptly cancelled the deal, citing national security and strategic needs. Years of planning and investment by Devas were wiped out overnight. The government argued the spectrum was too valuable for commercial use. Devas saw it as a breach of contract, a business-killing move. The official reason was national security, but Devas suspected other motives. The cancellation torpedoed Devas's business and set the stage for a global legal fight. India later accused Devas of fraud and corruption in the original deal. But at the time, it was a simple, brutal message. The government needs this, so you can't have it. The fallout: a once promising venture destroyed. Devas wasn't going down without a fight. The legal war was just beginning. Billions were now at stake, and the world was watching. Devas took the fight international, launching arbitration in Paris. In 2015, the tribunal sided with Devas, awarding over $560 million plus interest, now ballooned to $1.29 billion. But collecting from a state-owned company is never easy. Back in India, Antrix and the government fought back, calling the deal fraudulent. Indian courts ordered Devas liquidated, branding it a sham. The Delhi High Court then set aside the arbitration award, citing fraud and public policy. India's Supreme Court upheld these decisions. So, internationally, Devas had a billion-dollar win, but in India, the award was declared worthless. It's a legal tug-of-war. One side says pay up, the other says the deal never existed. The result? Total legal gridlock. Devas needed a new strategy. Enter the US courts. With Indian courts blocking payment, Devas tried to enforce the award in the US. But Antrix claimed sovereign immunity under the Foreign Sovereign Immunities Act, FSIA. US courts usually can't hear cases against foreign state-owned companies unless an FSIA exception applies. The Ninth Circuit tossed Devas's case, saying Antrix lacked enough ties to the US, but the Supreme Court disagreed. They ruled, if an FSIA exception applies, you don't need extra minimum contacts for personal jurisdiction. FSIA itself sets the rules for when US courts can hear these cases. Justice Alito wrote that Congress intended FSIA to be the full framework. If the exception fits and the company is properly served, the case can proceed. This was a huge win for Devas. Their billion-dollar lawsuit is back on track in the US. The Supreme Court just made it easier to sue foreign state-owned companies here. The legal door is wide open. Why does this matter? The Supreme Court's decision clarifies how foreign state-owned companies can be sued in the US. It's a big deal for international business and arbitration. Companies now have a clearer path to enforce awards against foreign governments in US courts. But the fight isn't over. Antrix still has defenses, like arguing Indian courts already voided the award. The case returns to the Ninth Circuit for more battles. This saga shows how complex global business disputes can get when governments are involved. Conflicting rulings in India and abroad make for a legal minefield. The Supreme Court settled one key issue, but the billion-dollar question remains: will Devas ever collect? For now, the legal drama continues. Billions hang in the balance. The world is watching. The next chapter is coming. Stay tuned.